It has to be noted, as I stated earlier in this ruling, and for which there are several judicial decisions in this country, that the 180 days imposed on election tribunals and courts hearing election petitions is immutable.
Yes, you all, it's Peace TV on today's episode, and practically we're talking about the Supreme Court on today's judgment connecting with Tinubu, Atiku, and Peter Obi. Recently, the Supreme Court has kicked out Obi's petition against Tinubu and Atiku's petition against Tinubu. And obviously, President Tinubu is now the president of the country. I would like you to watch the Supreme Court hearing on today's judgment. And finally, whether we like it or not, President Tinubu is now the president of Nigeria. Thanks for watching. It's Peace TV. Please don't forget to subscribe, comment, and share this video. Thanks for watching.
And cannot be extended. The applicants have not even applied for extension of time to bring in the said depositions or extension of time to amend their petition. Let me say it clearly that 21 days provided for the filing of petitions having long expired, even if the appellants had applied for extension of time to amend their petition in order to bring in the depositions, it would not have been granted based on the provisions of the Constitution and the Electoral Act. This principle was again restated by yet again Onogen JSC as it was in NNPP and Goni. Citation supplied when he said, despite the decision of this court since October 2011 on the time fixed in the Constitution, some of the justices of the lower court still appear not to have gotten the message. From where will the election tribunal get the jurisdiction to entertain the retrial after expiration of the 180 days assigned by the Constitution? The answer is obviously in the negative. It should be constantly kept in mind that prior to the provisions of Section 285(6) of the 1999 Constitution as amended, there was no time limit for the hearing and determination of election petition by the election tribunals or the appeals arising therefrom. That situation resulted in undue delay in the hearing and determination of an election petition by the election tribunals or appeals arising therefrom. The amendment to the original Section 285 of the 1999 Constitution by allotting time within which to hear and determine election petition and appeals arising therefrom is designed to ensure expeditious hearing and conclusion of election matters. If the decision of the lower court is allowed to stand, as urged by the respondents, it will reintroduce the earlier mischief which the amendment sought to correct. End of quote. See also Uba and Suswan. Citation supplied. The above statement by this court is very explicit, clear, and simple. As it is, the provision of the Constitution has spoken. There cannot be an addendum or another reopening of the case at the lower court, its jurisdiction having lapsed. My noble lords, I've taken time to state the law on the issue to show the futility of this motion. It cannot be granted. The jurisdiction of this court is donated by the Constitution and the Electoral Act regarding election petition appeals. We do not have the virus to admit this position, and we cannot invoke Section 22 of the Supreme Court Act, since the lower court has since lost its jurisdiction. More so, there is no paragraph of the petition to accommodate a case of forgery. Again, the appellants have distilled 7 issues for the examination of this appeal, and none relates to certificate forgery. One wonders what the appellants intended to do with the deposition, since appeals are heard on the issues distilled for determination by the parties in this court. In Saliba and Jackson, 2002, for Nigeria Law Report, citations others supplied, this court stated clearly that all appeals are decided upon the issues formulated for determination. What this means is that any matter not covered by any issue for determination is of no moment. Should the deposition be admitted, it will float in the appeal as this court cannot exercise original jurisdiction even if we are to start a new case for the appellants. See Sanusi and Ayula, Kitex Industries, and Oceanic Bank citations supplied. Finally, my noble lords, on this application, I wish to state that fresh evidence is not received as a matter of course. There are conditions which must coexist before the court can grant this type of application, as can be garnered from the decided authorities of this court, which include, that's right, but not limited to Owu Buariri and others, and Igbo Oyosi and others, Supra, Adegbite and a motion, cases cited by the Senior Counsel by the second respondent. Simply put, the conditions for the grant of this type of application are that 1, the fresh evidence could not have been obtained with reasonable diligence at the trial. 2, such evidence, if admitted, would have important effect on the subject of the appeal. 3, such evidence ex facie is apparently capable of being believed. 4, such evidence would have influenced the judgment of the lower court in favor of the appellants had it been available. And 5, and if such evidence is admitted, further evidences from the opposing party would not be needed. Taking the first condition, for example, the appellants failed to convince this court on why it waited until after the court below delivered judgment in the petition and lost the 180 days donated to it by the Constitution before bringing the said deposition sought to be admitted in this court. It has to be noted that appeals are a continuation of hearing of the matter in the lower court. As was pointed out by the learned Senior Counsel for the first respondent, A.B. Mahmoud Esayan, the presidential election was conducted on the 25th of February 2023, and the first respondent declared the second respondent as winner of the election on 1st March 2023. Thereafter, the appellant filed their petition at the registry of the court below on 21st March 2023. If I may ask, what attempts did the appellants make between the publication of the second respondent's form EC9 and accompanying documents in June 2022, a year more than a year ago, and the date of filing the petition on 21st of March 2023 to obtain the documents from Chicago State University, which could have been used at the trial court? Again, what attempts did the appellants make to obtain these documents between the date of filing the petition and the conclusion of trial? To say the least, the above questions are critical in the quest of this court's efforts to decide whether the new evidence sought to be adduced could have been obtained by the appellants with reasonable diligence for use at the trial. And with due respect to the appellants and their counsel, I think they were a bit tardy and were not reasonably diligent in their attempts at obtaining the documents which they seek to have this appeal. In Adeleke Aserifa Asupra, this court held that where the evidence is available and could with reasonable care and diligence be made available to the applicant at the time of the trial, as in this case, the court should refuse to exercise its discretion to receive such evidence. From all I have stated above, it is crystal clear that the additional evidence by way of deposition or oath does not fit into the issues submitted for the determination of this appeal. The application, my lord, of the appellant applicants in the circumstance is hereby refused and accordingly dismissed.